Good evening. My name is Christiana Zilke. I am president of the League of Women Voters of Berrien and Cass counties. I will try to speak loudly enough for everyone to hear. I want to welcome everyone to this Judicial Candidates Forum. Thank you for coming. For those who would like to see or hear this event again, you may do that. Why not suggest to your friends that they also watch and listen to it too? We are making a video recording and will be posting it online thanks to an equipment purchase grant our league received from the Pokagon Fund. This forum is being recorded for later broadcast by WRHC 106.7 FM, Three Oaks, Michigan. It can be heard on Monday, October 20 at 10 a.m. and again on November 3 as part of the station's pre-election coverage. If you do not live in the greater Three Oaks area, go to Radio Harbor Country, that's one word, radioharborcountry.org for listening options. The League of Women Voters is proud to be a support group in the electoral process. All across America, at the local, state, and national levels, the League is the one nonpartisan organization that consistently works to promote good government and encourages citizens to become informed and to vote. If you want to become a part of this team, we'd be happy to have you become a member. You can find a membership form at the check-in table on your way out. I want you to know we welcome men in this organization. Our co-sponsor for tonight's forum is the Berrien County Bar Association. Other Forum Week sponsors are the Dowagiac Rotary, the Four Flags Area Chamber of Commerce, the Greater Dowagiac Area Chamber of Commerce, Harbor Country Chamber of Commerce, Leader Publications, Delta Kappa Gamma Society International, and the Rotary Club of the Three Oaks area. Thanks to the League members who made this event possible and to those working here tonight. Our special thanks to the Berrien RESA, its superintendent, Dr. Kevin Ivers, and his staff for the use of this facility. Now it is my pleasure to introduce our moderator for the 5th Judicial District Forum. He is Jeff Gilbert, longtime League member and a retired attorney. He will be our guide through tonight's debate. Jeff?
Thank you, Chris. I want to take a moment to encourage those of you sitting in the back of the room to move forward if you have any questions about whether or not you'll be able to hear. Anyway, thank you for the introduction. Chris, everyone in this room knows that good government does not just happen, and that an important, indeed an essential component of our government is the judiciary, which consists of trial courts, intermediate appellate courts, and the Supreme Court. On November 4, voters in Berrien County will decide which of the candidates seated here will become a member of the Berrien County Trial Court. The Michigan Constitution requires members of each branch of government to swear or affirm that they will support the Constitution of the United States and the Constitution of this state, and that he or she will faithfully discharge the duties of the office to which he or she has been elected, according to the best of his or her ability. The purpose of this forum is to help you, the voters, decide which of these two candidates will be best able to discharge the important responsibilities of judicial office in Berrien County. Our candidates tonight have agreed to the following rules for this debate. Each candidate will be asked the same questions which were prepared by members of the League of Women Voters and of the Berrien County Bar Association. There will be no questions from the audience. Each of the candidates has affirmed that they have not seen or otherwise learned of the questions before tonight. The candidates will have a set amount of time, 2 minutes, to answer each question. There will be no rebuttal, although the moderator is permitted to ask follow-up questions. When we have finished with the questioning, each candidate will then have 2 minutes for a closing statement. Our timing this evening is League member Marilyn Clowder. She's seated in the second row. She will hold up a yellow paddle when 30 seconds of answer time remain, and a red paddle when time is up. We ask the candidates to observe these rules and to stop talking when they see the red paddle. Neither candidate is obligated to use all 2 minutes, the whole 2 minutes. We'll begin with opening statements. And Ms. Howard will go first, then Mr. Smith. Ms. Howard.
Good evening. Thank you. Is this working? Can you hear me?
Put it right up to your mouth,
Okay.
like a rock star.
I am a rock star.
Right.
I'm in life. As I said, thank you again, all of you, for coming. Thank you to the League of Women Voters and the Bar Association for co-sponsoring tonight's event. I appreciate the opportunity to get to know some of you better. I thank my family and friends who have come here tonight. I know it's a busy evening, it's a busy time of year this fall, so I appreciate especially those of you who maybe haven't made up your minds yet between the two of us to become educated voters. That is part of the process, and we really appreciate both Steve and I that you're taking your time to get to know us better before making your decision. So thank you, and I look forward to answering any further questions.
Okay, Mr. Smith.
Good. Thank you. Good evening. My thanks also to the League of Women Voters of Berrien and Cass counties and the Berrien County Bar Association for sponsoring tonight's forum. Very honored to be here and to speak to all of you. You know, I've been very fortunate to live and study and work in some remarkable places. I was fortunate enough to be in the nation's capital and in London, England, and places far from home. But no matter where I've gone, I have remembered, never forgotten, that I'm from Berrien County. I grew up in Coloma. And everywhere that I've gone, I've also remembered that the reason that I've been able to go these places, to see these amazing things, to accomplish a good deal, is that I'm from Berrien County. This county was what launched me. Being able to grow up in this area with this, the community that we have, the people who surround us, our schools and our businesses and government, that was a platform from which I've been able to go a number of places. But I'm excited to be back in Berrien County for the last 7 years. And I've been committed to returning that favor that I was granted by being of service, trying to be of service to Berrien County and the people who live here. I've been very active since returning, and I'm running for judge so that I can continue to be of service to this county and her people, and continue to make this place better and better as we enjoy it. Glad to be here. Thank you.
Thank you, Mr. Smith. The first question will be answered by Ms. Howard, and that is, what in your life experience, particularly your experience as a lawyer, do you believe qualifies you to be a judge?
A number of things. First, I think my background, again, I like Steve, I was raised here in Berrien County. My father is an immigrant from the Philippines and has brought with him a commitment to both education and hard work. He has bestowed that on me and my siblings. So part of my qualifications comes from my upbringing, from my parents, my family and their support, and that importance in raising now my own family. My educational background, I started elementary school in Benton Harbor school system, and then graduated middle school and high school at Lake Michigan Catholic. I have an undergrad from the University of Michigan, BA in economics, and I received my JD, my Juris Doctor, from Wayne State University. I did also take some time off in between my undergrad and deciding to go to law school after finishing at U of M. It was 4 years. My parents said, maybe you should get some practical experience. Make sure you want to. It's another 3 years of school. Make sure that is what you want to commit yourself to. So I did return to Berrien County. I worked for All Phase Electric Company. Many of you may have remembered that company. And then going forward, I decided to go to law school, finished there. I've worked a number of years in private practice, both through municipal, and today I am corporate counsel for the county, which gives me both a litigation background and administrative experience, which I think uniquely qualifies me for that seat in the judiciary.
Thank you, Ms. Howard. Mr. Smith, the same question. Would you like me to state it? Yes.
Would you please?
What in your life experience, particularly your experience as a lawyer, do you believe qualifies you to be a judge?
You know, as I alluded to, the experience I've been able to assemble, the accomplishments that I've had have been extensive. After graduating from Lake Michigan Catholic, which we shared, Donna and I went to Notre Dame for college and then out to Georgetown Law School in Washington, D.C. That opportunity of being in the nation's capital, learning the law, where the laws are made, and then beginning my practice there has really given me an extraordinary a basis from which to be a leader and an attorney. My first job out of law school was with the U.S. Department of Commerce doing government ethics law, which was an excellent tie-in with my time on the staff of the Georgetown Journal of Legal Ethics. It was a great opportunity to begin with. I then got into private practice in Washington, D.C. and suburban Virginia. But it was coming home and bringing that experience with me, I think, that has created those qualifications for judge. Not only continuing to practice as an attorney in St. Joe for the last 7 years, but also becoming involved in the community since coming home. As I say, I wanted to be involved and be of service to my community. In these last 7 years, I've been involved in a number of organizations. I'm proud to be on the Lakeland Health Foundation Board of Directors, serve on the Berrien County Land Bank Authority since its inception. Also with the Lest We Forget organization, a number of other organizations, trying to be involved and do my part and serve the people in volunteer ways. So I think it's the combination of the life experience as an attorney and where I've been and since coming home, but also the record of service that prepares me well to be your next district court judge.
Thank you, Mr. Smith. The next question, you'll answer that first, which is Berrien County has a unified court system. Explain what that is and tell us your understanding of what your responsibilities are likely to be within that unified system if you are elected.
Very good. Well, excellent question to answer in front of several judges who are in the crowd. The unified trial court is rather unique here in Michigan. The old divisions between the circuit court and the district court and the probate courts have been broken down here in Berrien County in an effort to be more efficient, a better use of our judges and a better application of the caseload. Now the judges come together from their various courts and work in 3 divisions within the court: the criminal division, the family division, and the civil division. And circuit and district judges can work together more as a team in each of those sections and be focused in criminal docket, civil docket, family docket. As I understand my role, it'll be, first of all, to be assigned to one of those divisions at the start of next year. I will be the new guy. I'll be the young person, so I expect that I will be told what division I'm in, and I would gladly accept that assignment and go to work. I would be delighted to be in any of those divisions, to serve in Niles or in St. Joseph, and to be part of that team within the division, to contribute to the efficient and effective provision of service to the community that the courts provide. It'll be my job to be part of that and to help continue to keep our legal system here in Berrien County strong.
Thank you, Mr. Smith. Ms. Howard, I'll reread the question for
Please.
you. Berrien County has a unified court system. Explain what that is and tell us your understanding of what your responsibilities are likely to be within that unified system if you are elected.
Well, Steve did explain it correctly in terms of what it is and how it differs from the majority of the counties in our state. There are only a handful of counties that have chosen to go to a unified court system or concurrent jurisdictional system like we have. I appreciate it. I've practiced in both types, in both the normal district, circuit, probate scenario that most of the counties operate under, and our unified system that we have here in Berrien County. And I prefer the unified system, so I'm very happy we have it here in Berrien County. It allows the talents, we all come from different, we're all lawyers, we're all, have our license to practice in the state, but we all come from different perspectives, we have judges that have come from the prosecutor's office, we have judges that have come from private practice in the civil area. Both Steve and I practice primarily in the civil arena. We have other attorneys that come from more of a family type of area of practice. So I think it is a true benefit to the community to have a court system where those talents can be focused in, and you can also have kind of an economies of scale in terms of docketing and those types of things that we have are fortunate to have here in Berrien County. I would go, obviously, wherever the chief judge decides I would best serve the court system as a whole. My background is in civil, and I would, fit well there. I have had experience and had to appear in all three divisions of our Berrien court system since practicing here since 2005. So I welcome the challenge that any of the divisions will provide, and thank you.
Thank you, Ms. Howard. You'll go first on the next question, Ms. Howard, which is, are there any types of cases you believe you would be particularly well qualified to adjudicate within the unified court system? And explain your answer, if you would.
Yeah, following up on my prior answer, really, I've going into my 17th year of practice. It has focused on the civil area of the law. I've represented a number of municipalities. I have had to appear in criminal court as well as family court on some probate and pro bono work in other areas, but I believe my focus and my talents, the types of cases that I've handled, are mostly in the business court and civil arena, and that is where I believe I would have the most comfort based on my 17 years of practice.
Okay, thank you. Mr. Smith, your answer to that same question?
Yeah, and my answer is similar. My 16 years of experience have been primarily in the they've been in the civil realm, so that would be the shortest learning curve, I guess, of any of the three. I've also had some experience with the criminal side of things, not so much with the family, but I'm confident that with my education and experience that I have the ability to climb that learning curve, whichever division comes along. There are some exciting opportunities as well through the trial court because of some of the newest iterations with the court. Donna mentioned the business court, which is a relatively new distinction within the civil division, and that's an effort to try to focus business corporate matters within sort of this docket. It's an effort to specialize, which I think is becoming more and more certainly what we're finding with Berrien County is the ability to specialize our courts to tackle particular issues. So that would be an exciting opportunity to work in the civil division to handle business court matters. I've had a number of corporate clients through the years and dealt with a number of business issues. But I'd be excited as well to work with our newest, our mental health court and drug treatment court that the criminal division has. And so I can certainly bring education experience, and I think I'll bring a passion and a verve to want to dig in and be of value to the court and to the community. So I'm looking forward to it no matter where I land.
Thank you. Mr. Smith, you go first on the next question, which is describe what you consider to be appropriate judicial demeanor and explain its importance to the judicial process.
Very good question. It's, you know, I think that as I understand the role of a judge and what I'd be called on to do, it's, I'm going to set the tone for the courtroom. However I come in and the demeanor that I have is going to permeate through the prosecutors, the attorneys, the defendants, the plaintiffs. I think that the demeanor must be, first of all, a temperament that's even, steady, and an openness to be even-handed and fair, open-minded, and transparent. I think that our judges are asked to do almost a superhuman feat, to come to work every day and be consistent, to be the same person today that they were yesterday and tomorrow, because people are coming before us to have very important matters that could be life-changing to them dealt with. And I think the judge must find that within themselves to be a steady, calm, patient influence and person at the courtroom. And I think that's so important because process is as important as results. Our faith in the legal system is not just in what the outcomes of trials and prosecutions are, but also the sense that we're getting a fair shake when we go to the court, when we have to be in front of judges, that we're going to be treated the same way that others are. And so that's a huge task. And I look forward to living up to that. I'm confident that my skills, my temperament, my talents prepare me to be that steady influence.
Thank you. Ms. Howard, what do you consider appropriate judicial demeanor, and explain its importance to the judicial process?
Yeah, I think I might approach it just a little bit different than Steve. I don't view the judges, and no disrespect to those judges that are in the room, I don't view that job as superhuman task. I believe it's another extension of being a lawyer, and it's just a different role you are filling as a jurist. So I would carry over the same demeanor I have practiced with for 17 years, and that is treating all the participants of a process of the litigation with respect and integrity, and that's how I would expect my courtroom to be run, and would expect that not only of my staff, but I think actions speak louder than words. So that is the way I try to carry myself in my everyday practice, is regardless of where you're coming from and your background, everyone's there because there is a disagreement about something, and it is our job, whether as lawyers advocating for our clients or in the position of a judge, I think, to make sure that everyone has a fair opportunity to be heard, that the statutes are upheld in the Constitution, that there is due process, and that everyone in that process is treated with respect and dignity throughout.
Thank you. Ms. Howard, you go first on the next question, which is as follows. It is said ours is a government of laws, not men. What does that phrase mean to you? How, if at all, is it relevant to the work of a judge?
Could you repeat that one more time?
It is said ours is a government of laws, not men. What does that phrase mean to you? How, if at all, is it relevant to the work of a judge?
It's very relevant, actually. I approach and I perceive that as a judge, I'm going to apply the law and the rule of law approach to applying those rules. So it isn't what I may personally believe as a judge, whether somebody is guilty or innocent, whether one party should be awarded damages or not. It is the legislature that decides. We are fortunate to have 3 branches of government and in our system. It is what our founding fathers established, and I believe in that system as a democratic process. So it is for the legislature to decide the statutes and the laws, and it is the job of the judiciary to interpret those laws and apply those laws as they're written. It is not for man or woman to decide how those parties should be based on their own personal views of that particular issue.
Thank you. Mr. Smith, same question. Do you want me to repeat it?
No, I appreciate that. Yeah, I think there's a good deal of point to that. We look at our judges, and I guess this goes to my point about what we ask of judges, is that this country functions and has functioned so well for centuries because we have been a government of laws, not of men. We don't go into court and hope that this particular judge will like the way we look, or had his or her Wheaties that day, is feeling good and rules for us. It's supposed to be the application of those laws which have been created through the political process that we've all had an opportunity to be involved in and hold our representatives accountable. And the judge is there to apply those laws, not to be a rule maker, a decider, but to take those laws that have been written, regardless of whether the judge thinks them to be wise or foolish or well-crafted or not, and to apply them, because the accountability is with the legislature. We have our opportunity to send people to Lansing and to our townships and our cities to make these determinations, and we expect our judges to apply the laws. Now, it's not a mechanical process. There are lawyers writing these laws in our localities, and sometimes it requires interpretation. But then the task becomes trying to determine what is the intent of the legislature in the law, not how do I feel about this law, how do I think this ought to be applied, or what it should have said. So it comes back again and again that the judge has to apply the law, not be the determining individual who makes the decision there in the courtroom.
Thank you, Mr. Smith. The next question, how much and in what way should a judge's personal opinions influence his or her decision-making?
I think the task for a judge is to remove their personal opinion. Again, we are applying the laws. If you begin to assess the laws or the parties or the dispute in terms of your own personal opinion, your own values or life experience, then we've begun to get away from that system of laws. I do think there's an opportunity for judges to be like us, to advocate or speak with our legislators, and judges have a unique opportunity to see in their courtrooms every day what's happening, what's working, what's not, what's going wrong, where laws may have problems, and so they have the opportunity to share their opinions with the legislators. But again, that's not in the role of judge. That's sharing their opinions from their experiences and hoping to make the laws better. But in that courtroom, there's not a place for personal opinion. It's really an affinity, a commitment, a dedication to this system of laws.
Thank you. Mr. Smith, Ms. Howard, the same question. How much in what way and in what way should a judge's personal opinions influence his or her decision-making?
Yeah, I think from both Steve and my answer, you know that we are approaching it from a rule of law perspective, and really personal opinion of a judge, it's part of your oath in becoming a judge that you are not supposed to let that influence your decisions. You apply the facts during a trial. You let the fact finders do their job, the jury to do their job. When there's a bench trial, and the judge just gets to decide. So you have to, and it's not an easy task. I'm not saying that. We don't operate in a vacuum, and we're not robots. So we all come from a different perspective, but that is different than applying your personal values to a decision. So people have to kind of judge who we are in voting for us, and our backgrounds and where we come from. But at the same time, you have to trust that both of us will, I believe, and I would hope, uphold our oath to separate our personal values from the decisions we are making on the bench.
Thank you, Ms. Howard. The next question is yours to go at. First, do you believe a judge has a special obligation to a litigant that appears before him or her without a lawyer? If not, please explain why. Otherwise, please explain your understanding of the nature and extent of that special obligation.
Yeah, actually I do. Only because I've been involved in cases where the party is represented, and I've been involved in cases where they're not. And it is difficult for a non-lawyer really sometimes to process through a litigation and a prosecution. So when somebody is trying to represent themselves, we've had the benefit of 3 years of schooling, of years of experience, to practice those skills, to learn the court rules and how things are supposed to proceed. Somebody who is not represented by a lawyer doesn't have that, necessarily have those talents to do that. And so I think as a judge, your obligation is to make sure they are given the opportunity and the direction of where to go to find that answer. If they on their own decide not to learn those rules and to follow, then that puts, that is a different story. But you have to a lot of time take extra time. I've seen it through my own personal experience in cases, and I try when I have whether it's a plaintiff or a defendant on the other side who isn't represented, to make sure that I am giving them the extra time and knowing that it's going to take them longer to understand the process, give them as much information as I can so that they don't feel like they haven't been given their due process rights.
Thank you, Ms. Howard. Mr. Smith, do you believe a judge has a special obligation to a litigant that appears before him or her without a lawyer? If not, please explain why. Otherwise, please explain your understanding of the nature and extent of that special obligation.
I do think there's a special obligation, and it's not just for the person appearing without the attorney. It's for the judge as well. I experience it most commonly in landlord-tenant matters. I've had tenants, individuals come to court. They don't have an attorney. There are forms to complete. There are waivers to fill out and to sign. And you will notice the judge take a great deal of time to go through the steps of being certain that this individual understands what's happening, what is being asked of them, why they're there, what the potential cost to them is. And I think that's a vital duty to the judge as well, because you want to know that this application of justice is being applied clearly and thoughtfully, that you know that this person has come before you, understands every step along the way. You want to be confident that when you make that decision, whatever it is, that you know that that individual has had the benefit of understanding the process and their rights, and you can have more confidence in your decision. So I think there's that special duty to an individual who's wading into the complicated legal system, and a duty to the judge, him or herself.
Thank you, Mr. Smith. On a somewhat related issue, the question to you, Mr. Smith, first. When a party has a lawyer, does the judge have any obligation to ensure the lawyer's representation is adequate? Would your answer be different if the party was indigent and the attorney had been appointed?
Well, I think it has to be consistent. The answer to your question is yes, there's a special duty even when there are attorneys there, and there has to be a consistent concern whether, whatever the attorney is, whoever represents the people that come before you. The judge, as I said earlier, sets the tone, is in charge of that courtroom, and has to be confident that all people who are before him or her understand what's happening, are meeting all the requirements and all the the duties before them. I think with indigent defense has been a particular concern in this state. We've started a commission to try to look at ways to improve indigent defense, and I think the judges are right to have, with that experience of the challenges of indigent defense, be perhaps a little more focused on the defense that's being provided. But I think across the board, the judge has to be confident and make him or herself confident that the representation that's being provided in the courtroom is providing what needs to be done so that everyone understands this process and what the challenges are of an ever more complicated legal system.
Thank you, Ms. Howard. Would you like me to reread the question?
No, I think
Okay.
I think lawyers being involved in the system, then you have more of an even playing field procedurally. But I do not see really a distinction between, in my personal experience, in our courts with the representation, whether or not it's an indigent defendant or the defendant is able to pay and hire their own defense attorney. Having worked for the county these past 4 years and being involved in the indigent defense contracts, I am confident with the indigent defense attorneys that the county has retained to represent those clients to the best of their ability. So I believe that as a judge overseeing, it is not as much a difference between whether or not the defendant themselves is paying for it, that particular lawyer. All of our lawyers in Berrien County who also do that type of work, it's not easy work, and I believe they use their experience just like the rest of us in applying that to the best decision and recommendations for their clients.
Thank you. Ms. Howard, the next question is also yours first. What, in your opinion, is the best way to ensure that the law is fairly administered in the disputes that come before a judge?
I believe through the statutes and particularly the court rules that are established for litigants and prosecutors to proceed with cases. Those are the guidelines, those are the rules set, and I think in following those rules, you are able to establish a decorum, you are able to maintain respect for the parties, and that is, what I always try to follow and look to as our guiding factors to make sure that all the participants are getting a fair shot.
Okay. Mr. Smith?
Repeat it.
Yeah. What, in your opinion, is the best way to ensure that the law is fairly administered in the disputes that come before a judge?
Well, the best way is for an educated populace to make a careful decision of their judges. This is a unique opportunity this year. This is the first contested judge election in 10 years in Berrien County, so that it's a great challenge to the people to be knowledgeable about those who they are making this decision on. It starts with the judge. It starts with the individual who is tasked with applying the laws as they're written. That person has to be committed to the rule of law, committed to subsuming their own personal opinion, their own feel about any given statute or ordinance. I'm confident with the way that I was raised and here in Berrien County and the education experience that I've had, that I'm prepared to do that. It's got to be a commitment day in and day out to making the law the primary thing. And then the judge working together with the attorneys who should be seeking the application of the law and hopefully the parties themselves. That's how we get to the best application of the law. But it starts with the judges, and that's why forums like these are so important.
Thank you, Mr. Smith. The next question is to you first, and it is explain the burden of proof and the role that it plays in determining the outcome of the trial.
Well, we have to make a decision, the legislature has to make a decision as it creates laws and as to which parties have the burden of proof. It has to start somewhere. Someone has to have the obligation of being persuasive in their point of view in any dispute. In the criminal matters, the burden of proof lies with the prosecution, because in this country we'd rather see 10 guilty people go free than one innocent person go to jail. And so such an onus is put on the prosecutors to prove the case. In the civil practice, as we've been used to, Don and I, the burden of proof depends on what the given claim is, what statute you're dealing with. But typically on the plaintiff to prove why we're all here in court, why this case has been brought, and what are your what's your harm, what are your damages, and then in many cases the burden can shift then to the other side to prove the opposite. But it has to start somewhere. There has to be someone with the burden of proving their claim for being in court and having a dispute, then that's the individual who has to be successful. Otherwise, then there's no reason to be in court, and the case will be dismissed.
Thank you. Mr. Smith and Ms. Howard, the same question. Explain burden of proof and the role it plays in determining the outcome of the trial.
The burden of proof, and Steve and I could probably talk on and on trying to explain the different aspects of the burden of proof, but in 2 minutes or less, the burden of proof are really the standards set, again, by the legislature on different types of cases. For instance, Steve mentioned criminal. Because in criminal matters you are talking about somebody's personal rights, their constitutional rights. Somebody may be losing their right to be free if somebody is found guilty of a crime. That burden is not just on the prosecutor, but it is a burden of a beyond a reasonable doubt. Many of you may have seen that on television shows and things like that. That is the highest burden to prove, beyond a reasonable doubt. So you sitting in a jury having to judge whether somebody has done something right or wrong, that is the highest burden that our legislature has set for that, because those rights are so important to us as individuals, as free, independent individuals. You have civil matters, and you have some lesser crimes that maybe the burdens are lesser. You hear of preponderance of an evidence a lot of times in, let's say, a personal injury case or something like that. The jury or the fact finder has to decide that case based on simply preponderance or a majority of the evidence. So there are different burdens set for different types of cases, depending on what rights people have and the types of claims that are being made.
Thank you, Ms. Howard. The next question is to you first. In Berrien County, alternative dispute resolution procedures such as mediation and case evaluation are required in certain types of cases. In cases that come before you where such procedures are not mandatory, will you, as part of your regular case management procedures, require or encourage parties to engage in alternative dispute resolution efforts? If so, in what types of cases? If not, why not?
In the civil arena, we run into that many times, and really it would depend, as a judge, it would depend on the circumstances of the case, the type of cases, and really where the parties have postured themselves at early on in the case. A lot of times judges can get a feel for that from the lawyers themselves, that, Your Honor, we have been having communications, but we haven't been able to come together. So this lawsuit was filed to resolve the ongoing dispute. In that instance, a judge may decide that an early ADR, or an alternative dispute resolution method, might be helpful to save the courts, save time and resources of the parties by going that route. Sometimes the issues before that you can read in a complaint initially are too complex that more litigation has to occur first before you would force that on the parties. And if you want people to come together and try and mediate an issue, you really want them to be coming voluntarily. So as a judge, I wouldn't force that if I didn't think the parties were ripe for something like that early on in a case. I may require some additional discovery and that sort of thing before I would order that type of method of resolution.
Thank you. Mr. Smith?
You look at my business card, it says, I have two titles actually. I'm an attorney and a counselor. And I'm proud of the counselor aspect as well. I'm as proud of the matters that didn't go to trial, the matters that got resolved before I got very far along in the court process, as I am of those things where I've had to appear in federal and state court and in several jurisdictions. And I think that's going to carry over with me to the court, looking for every opportunity for parties to resolve matters before they proceed all the way to trial. I think Donna makes a good point. There are cases it's going to be very obvious that sending folks to spend an afternoon with a mediator is not going to get anyone anywhere other than having lost a beautiful afternoon. But I think my instinct is going to be toward trying to encourage parties to seek those alternative ways of resolving their disputes. You know, we have such a heavy caseload in our court, and folks can often tend to jump to a lawsuit when they've got a dispute, and it's only typically when the attorney's fees start mounting up that they realize, gee, I didn't dislike that person as much as I thought I did. So, you know, in my experience, there's typically opportunities for resolution, and I would not hesitate to take an opportunity to push the parties as I could toward that end.
Okay, thank you. And Mr. Smith, the next question, which is also the last question, you will go first. It is as follows. Should a judge avoid or limit socializing with members of the Bar Association who represent litigants before him or her? Why or why not? And explain your answer.
That's a very good question, and I'd be interested to have that question asked the other way around to attorneys as well. I think that while there is a need to have that distance, I think that the attorneys and the judges understand the very sacred duty to avoid the fraternization that bleeds into work. You don't want to get into a situation of attorneys and judges being not necessarily conspiring or doing anything wrong, but even having the appearance of impropriety. Again, it goes back to the faith that we have in the legal system. You have to have the confidence that the professionals who are judging and serving as attorneys are upstanding and fulfilling their oath. I think there's a great benefit to judges and attorneys being able to communicate outside the courtroom. It's not, judges don't disappear behind a wall and we only see them when they come out in their robes. It should be, they are members of the bar, and there is a benefit to especially young attorneys to be able to meet and learn from judges. And I think that everyone keeping a clear focus on their responsibilities and their obligations, not to go over that line, I think those opportunities to communicate with each other are important and should be preserved.
Ms. Howard, should a judge avoid or limit socializing with members of the Bar Association who represent litigants before him or her? Why or why not? Explain your answer.
No, I don't think they should avoid socializing with the rest of the bar. In fact, they're an integral part of the Bar Association. We have an active bar, and we get together, and I think attorneys become better by being able to exchange ideas, meet for forums. We do lunch meetings sometimes where judges or other attorneys will give presentations. We want to be able to serve our clients, whether it be a municipality or a private individual, whether we're working in the courts, the best we can to serve our community. So I think as a collective bar, we've done a good job about that. And I've never experienced that in my 17 years of any type of crossing that line in witnessing a judge do that. So as we've socialized and met together as councils and learned from each other and mentored younger attorneys, I think it's a necessary part. So I would hope I wouldn't have to avoid that in becoming a judge, to meet and learn from my fellow counsel.
Okay, that concludes the questions for this evening. We'll hear from each candidate a 2-minute closing statement. Ms. Howard will go for wait a minute. Mr. Smith will go first with a closing statement.
If there's one word to take away from tonight, it's service. Our judges provide an extraordinary service for our county, and for the most part, it's a service provided that we don't see on a daily basis if we're lucky. We just have the ability to be confident in going about our daily business, that we have people who are taking on that enormous challenge of applying the laws, interpreting the laws, and making decisions that affect people's lives. Service has been an important part of my life from the beginning. I was raised by teachers who went to work every day and earned a paycheck, but were serving the community every day. That's how I understood how you find your career, how you find your calling in life, is to find a way that you are giving back to your community, you are a contributing member of your society while you're earning your living and putting food on the table. That's why I went to law school. That's why I went out to Washington to challenge myself at Georgetown and practicing out in Washington, D.C. And it's especially why I came home 7 years ago and have been so involved in the community ever since. It is about making this life a life of service, doing something with your talents and your abilities to make the world that you're in a better place. I'm proud to work hard every day to make Berrien County as great for our kids as I experienced growing up here, and I would be honored to have you vote on November 4th to serve as your next district court judge. Thank you.
Thank you, Mr. Smith. Ms. Howard?
Thank you. I have 3 words, so I'll beat them by a couple. If you don't know me and haven't worked with me, the 3 words I hope you will leave here knowing about me is experience, respect, and integrity. I believe through my experience, both in private practice and working for the county, that I offer the best qualifications to meet the needs of the court at this time. In terms of my background and my upbringing, I believe I have grown into the person that will continue on the bench to give respect and integrity to the rule of law, to those participants who are in the system and trying to get their cases litigated. I'm very appreciative of the opportunities I've had, and I'm appreciative of the job that I currently hold with the county as their corporate counsel. I think that experience in having to deal with the administrative side, having to deal with personnel issues, has given me that added perspective of that will be beneficial to the bench. And I hope that in learning more about me, you will consider me for your vote on November 4th for a district court judge. Thank you.
Thank you, Ms. Howard. I'd like to invite all of you to join in a round of applause for these two excellent. And before we leave, I have a commercial note here, a commercial announcement. There are more forums this week. Thursday night, October 16th at 6:30 p.m. Both of these forums are at the Mendel Center. Senate District 21 John Prost against his challenger Betty Pearman, and Michigan House District 79 Al Pasholka against Eric Lester. Those candidates will appear at 6:30 p.m. At 8:15 p.m., Congressman Fred Upton and Paul Clements will meet for a forum at the same location. I hope to see you all there. Thank you for coming tonight.
Thank you, everyone.
Congratulations.
They were not